Hello and welcome to HSC 2017 ATAR Notes Legal Studies online lectures. This one we're going to be talking about writing essays. For the most part I'm using crime as an example, but you'll be able to take these things into your options as well, whether that be shelter or world order or family or consumers or any of that. You'll still be able to take a lot of these skills into that, whether it's how you analyze the criteria, whether it's the kind of terminology you're using, the structures and so forth. So starting super simple, I've just taken the marking guidelines from the 2016 HSC paper. The question was about young offenders. So in the criteria here, you will see young offenders terminology. That's okay. Ignore that and just imagine that you're replacing with whatever the question is. So I've taken a band 6. That is the aim ultimately, and I think you'll be surprised as we break it down what a small difference it is between a band 5 and a band 6, but the way all of those small differences works together to create that top band. So I've put band 5 down here as well. We need to make sure essentially what the criteria is checking is that we are answering the question, we're making a judgment, we're proving our point well, and that we're using good vocabulary, we're using correct legal concepts in the correct context. So that's what we'll be talking about here. Looking quickly here, we're going to be looking at the difference between a band 5 and 6 in each of these. So it's still asking the same things of you, but to a different extent. So we can see here the difference between a band 6 and a band 5 is a band 6 offers an extensive understanding of the section of the syllabus being inquired about, whereas a band 5 is about a substantial understanding. So the difference between a substantial and an extensive understanding isn't too great, but this one is very much about your preparation, how well you understand the syllabus and the implications of the syllabus. A substantial understanding is someone who can probably describe it really well, and in the situation of them having to explain the answer to an essay question to their friend, they could probably do so. An extensive understanding, I find, is that you're not only able to understand the topic, you're able to explain it in a really, really thoughtful way, essentially. You're really ticking all the boxes and you're showing you understand it really well. Then for the next one, the difference here is about the judgment you're making, and it's often a criticism of legal studies essays that we're either waffling or not making a judgment, or both, and the two very well can go hand in hand. So with a band 6, we're making an informed judgment. A band 5 is a judgment, informed or not apparently, explicitly or implicitly. What I think is really interesting here is if you even just agree with the essay question, you're pretty well saying you've made some kind of judgment, even if on an implicit level. So to me, that's standing out as to say that's reasonably easy, and I was surprised when I saw it in there. Explicit is definitely the way to go in my mind. An explicit judgment is showing that you're really tackling and taking on the essay question. An informed judgment, which is what takes us into a band 6, is not just any old judgment, a band 5. An informed judgment says that you've thought about what you're going to be discussing in the rest of your essay, and that you understand the topic well enough that you're not just going to agree, yes, it's super duper ridiculously effective in the entire thing, and instead you're making an informed judgment because you're considering the limitations, you're considering the different parties involved, and you're showing that you really understand the way the legal system has complications for different people, different parties, different backgrounds, different experiences. Where there's successes, there's usually limitations and so forth. When we're looking at using relevant examples of legislation, cases, media, international instruments and documents, for a band 5, we're just using them. And sometimes that's half the hassle. Making sure you're consciously engaging with legislation and cases and media is really difficult from a study note perspective, and that it needs to be in your study before it can even feature in your essays there. But the difference between uses is integrates is at what point you're using these media, legislation, articles and so forth, and exactly why you're using them. So if you're integrating them, you're using them to prove your point. You're not just using them to say, oh yeah, by the way, and I'll just tack on this media article at the end here to summarize my entire point. Instead, you're thoughtfully integrating the argument of the media article into the paragraph or into the wider essay. Or when it comes to your case, you're not saying, blah, 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 this is effective, this is not effective, etc., as seen in the case such and such. Full stop, next paragraph, on we go. Instead, you might be looking through the case to evaluate the system. So these are examples of the difference between uses and integrates. And the last part here, we can have a logical and cohesive answer if we're looking to the band 5, or we can have a sustained logical and cohesive. To me here, the difference is clearly sustained, and what this means is when you're in an exam, no matter how much you know, it's about the way you express it on the paper. And we do get caught up because in legal studies, we very rarely go through writing techniques to the same extent we do with our English essays. We know our English essays and the different things that the modules ask for, and we know the way we're supposed to be talking about them and what things to avoid. We don't go into as great detail with this in legal studies. So it can get a bit away from you when you're in an exam and you're stressed and you're pumping through it all and you forget to make your argument sustained, meaning that you're not going to sway back and forth like a plastic bag in the wind, hello Katy Perry, and instead you're going to be going through with an argument. And if you're going back and forth because you're showing different perspectives, totally fine to do that, but you're doing it in a way that follows a common thread. It's not scattered, it's not all over the place. You've really thought about it before you've put pen to paper. So to summarize that, you need to answer the question directly, you need to make a judgment, you need to use your evidence really well and skillfully, you need to be cohesive and obviously use the terminology correctly. So there's a lot of things there, but as you can see, the difference between a band 5 and a band 6, it's about getting there, putting in the work you've done all year. It's hopefully going to get you to around the level of a band 5, but with a few tweaks, that's what pushes you up into the highest part there. It's not about making huge changes a lot of the time. Part of the time, it's just about changing the way you're writing your sentences. So you're focusing on the case, you're focusing on your evaluation, whatever it is, it's about those smaller adjustments that make big changes. Students often ask, should I memorize in legal studies? And my personal opinion is definitely not. The possibilities are just too vast. You've got a whole syllabus there, and if you've memorized essays on young offenders, but you haven't memorized anything on international crime, which was my 2015 HSC question, you've really got yourself into a pickle. I would be far better investing my time in memorizing cases and legislation and understanding as opposed to memorizing different kinds of arguments and what their implications are. So I'm not memorizing arguments in the form of, yes, this is the essay, this is the way it will go, but I'm memorizing arguments in that this is the way I feel, but this is the way Sally that sits next to me feels, and together I'm going to memorize the way that these two work together to show successes and limitations, for example. So in short, no, I don't recommend memorizing legal studies essays. We're going to talk about your thesis or your argument here, whatever you would like to call it. I'm going to use an example that Jamin made, which is a really, really good example. But for now, I just want to make sure that we know it doesn't need to be fancy. It's not like our area of study thesis statement where we're thinking about it in a lot of detail to work out exactly what kind of modality we want to set for the entire thing. Yes, it's important, but it doesn't need to have all these fancy, beautiful words when it's going to be most effective if you're being really direct and clear with your marker. You don't have to put your entire judgment in one sentence either. So often legal studies students want to show that they understand the complications and the successes, the implications and so forth of a particular legal issue, which is excellent, but it doesn't need to be in the one sentence. So we do have an entire introduction to kind of shape our point, and then we've got the rest of the essay to prove the point. Your opinion really, really does matter, 110%. This could form the basis of your judgment. So you can't say, no, I don't have any legal evaluations. You totally do. When your teachers told you about a certain case and you thought, oh gosh, like that wasn't very fair, or you heard about something in the news and you thought, oh wow, like yeah, it serves them right. Whatever it is, your opinion does come into this, and you've just got to dig a little deeper to be like, why is that unfair? Or why does that serve them right? Hopefully throughout the year you've been creating opinions as to what you think is important and what you think is not, what you think is effective, what you think is not, and so forth. Make sure you do then establish these opinions. So you need to present effective, inquisitive arguments throughout, and at some point you may want to consider playing the devil's advocate. The reason I say this is if you're going to say something is entirely effective the entire way down the line, and then you get to the end and you realize that all you've done has been the biggest champion of the legal system the entire way, it doesn't give a lot of scope for your essay. And in reality, our legal system is not perfect. Whenever something is going really well somewhere, something is falling a bit behind the 8 ball in another section. So if you play devil's advocate, you allow yourself to go both sides on an essay in a really strong and directed way. So here is an example. You can Google and find this guide, Legal Studies Thesis Statement Guide, ATAR Notes that Jamin wrote. Here's the question. How effective are domestic and international measures in dealing with transnational crime? This was my 2015 HSC crime essay. Woo, triggered. Simply, international and domestic responses are ineffective in dealing with transnational crime. Very simply. They're ineffective, we've made the judgment, we've answered the question, this is good. Remembering how simple it was to be explicit or implicit in your judgment in order to get a band 5, we're already shaping ourselves up to do pretty well here. Taking it further, despite some successes, international and domestic responses are only partially effective in dealing with transnational crime. So this is important because we've got the despite some successes at the start. This is an excellent little phrase to use at the beginning here to show that yes, there are some successes, but it's saying despite, so there is places to go from here. There's a lot to discuss here, so that's really cool. You could leave it at this, and I would say this is an excellent thesis statement. I know exactly what your opinion is already, and I'm excited to see where you take it throughout the essay. So I'm in support of this kind of thing. Obviously, if you understand the topic area really well, already right from the outgo, you can take it further. I wouldn't take it any further than this, but I fully champion that this is an excellent thesis statement as well. Despite some successes, international and domestic responses are only partially effective in dealing with transnational crime due to a lack of multilateral cooperation. So that last bit there about the multilateral cooperation is me engaging with what's yet to come in the rest of my essay, in saying that this will be a common thread that we're going to approach throughout the entire thing because it is problematic. So how do you structure your paragraphs? There are so many different ways to do that. I've just picked a few that I've tried before, tried and tested. They work, but each different essay question will lend itself to a different kind of essay structure. They won't all go the same. So we can start with how do you structure your paragraphs? Legal and non-legal responses, by case, by affected group, by stage in the CJS, or by this funny little pattern I've got down the end here. We'll go through and we'll discuss these and it'll make a whole lot more sense. So if the essay question here is to what extent are legal and non-legal measures effective in dealing with transnational crime, for example, I might be looking at a legal measure per paragraph. I might let a single legal measure direct the paragraph, and then I'll look at different non-legal measures or other legal measures that feed into that bigger one throughout the paragraph. And I'll look at the way that together, rather in isolation, they work together to create something that's effective or not effective and so forth. So whenever there's a legal measure, there is often a non-legal measure as well that's either championing it or challenging it. So you can approach it like this. So just look at one legal measure per paragraph, but obviously you would only do this if the essay question lends itself to it like this one here does. You can also structure it by cases. So here's an example question. To what extent are sentencing and punishment procedures in the criminal justice system effective in achieving justice? In paragraph 1, I want to talk about mandatory sentencing. And I could take the approach of looking at the essay through the lens of mandatory sentencing, but instead I'm just going to shift it ever so slightly and look at it through the case that exemplifies some of the ramifications of mandatory sentencing. So I'm looking at R.V. Jacobs, which is the case of mandatory sentencing life imprisonment for murder of a police officer. It's a New South Wales case. So I consider the judge's statement, the legislation involved, and I'll analyse the way justice was achieved to the parties of the crime. And that's the way I'm going to look at mandatory sentencing for that paragraph. In paragraph 2, I might look at Bronson-Blessington. This case is about the juvenile sentence for life. If you haven't already got this case, I really recommend it. Have a jump online. There's a Sydney Morning Herald article called Locked Up for Life, and it talks about, it's an investigative journalism piece. It's really interesting, I found, to read it even from a non-legal studies perspective, so you can have a look at that. But that's a side note. So paragraph 2, another part of the sentencing and punishment I want to look at is life sentencing, especially with the implication of a juvenile involved. So I might look at the case of Bronson-Blessington, and then through that case, I will evaluate the effectiveness. And in paragraph 3, I might choose another case that exemplifies something about mitigating or aggregating factors or the use of defences. So potentially I'll look at the case of Kaisha Abrahams, for example. So this way you're privileging the case and you're looking through the case in order to evaluate the system rather than evaluating the system and using the case for support. Obviously, it can work both ways. This is just showing that you can invert it. By affected group, to what extent is mandatory sentencing an effective aspect of the criminal justice system? So this is an unusual question. It's definitely a question that you could be quizzed about. I might